Hello and welcome students. A good evening to everyone and कैसे हो आप लोग? Please do let me know. And we are back with our current legal affairs session that we do on every Thursday at 6 p.m. But today we are doing it on Wednesday at 5 p.m. From next week, we'll be doing it from 6 p.m. itself. So, yeah, how have you all been? Is it a good week for you? Okay, sure. Let us start with today's session. Okay, so we'll be covering the three important topics that are going on right now. And good evening, good evening. The three important topics that we have been seeing since last 2 3 weeks, and they are there in the they are the respectively there in the arena of legal vicinity, and those three topics majorly, if you want to see and cater the last week, there was this ruling that came into picture with respect to Supreme Court, where they have mandated 3 years of legal practice for judicial service aspirant. I think and I believe each and every aspirant has actually listened and heard about the same. Am I perfectly audible and visible? Just give me a heads up. Okay. So, and then there are two more things that we can look after. Is one is judicial accountability and the Veeraswamy ruling. Also, there is doctrine of presumption of constitutionality. Okay. So, moving ahead with our first and foremost, the topic that we have, key, what is actually judicial accountability and why it's there in the picture as of now. When we talk about what is judicial accountability, it actually refers to that idea that judges should be held responsible for their conduct, both on and off and off the bench, and certainly for the discharge of their judicial duties in a manner that upholds public trust and constitutional values. So, yes, that is all about what judicial accountability is. And basically, this is made so that there is a transparency which is maintained, and their judges had that responsibility to explain the decision and actions, right? They hold such a better position and such a high position that they have to be, certainly or the other, be impartial in nature whenever they're going to give their accountability for the same. That's why certainly these are a few important pointers that have to be there in our vicinity. So why it was there, why it is such a concern as of now? Because judiciary is actually a body that is the guardian of the constitution, if you really want to say, because they amend the laws. They actually have the power to amend whatever is written in the constitution of India, but then they have to interpret it in a better way so that we as citizens understand what our rights is and what are the major things that we perceive out of the constitution of India. Also, it has wide powers that it has tremendous powers. Being the judicial body of our country, it has the power of judicial review as well, yet it is largely self-regulating with limited external checks. So, yes, when we talk about judiciary as a whole, we have lesser check marks, check boxes that we keep as a whole, because certainly judges hold that position that we don't question usually to them, right? Okay, so why it was there, the major concern was because when we look back in the background of Veeraswamy case, a little bit about it. The Veeraswamy versus Union of India was the name of the case law, where Justice K. Veeraswamy, the former Chief Justice of Madras High Court, was accused of possessing disproportionate assets. So recently, all these things were there in the question as well. And the issue was whether a judge of the High Court can be prosecuted under the Prevention of Corruption Act 1947 or not. The challenge that came into picture was whether the executive could initiate prosecution of a sitting judge under what condition. So, majorly, all these case laws, when you see that the corruption case laws, the money laundering things, all these things, when you see with respect to a justice, it is actually what That is not what we perceive out of a judge, right? So here it was certainly some of the things that happened while the case was there, the overview of the case majorly. And what were the key verdicts about the same? That yes, judges of Supreme Court and High Court can be prosecuted under Prevention of Corruption Act. This was certainly the key verdicts of the same. However, prior sanction of the Chief Justice of India is mandatory. So yes, certainly or the other, the prior sanction of the Chief Justice is really mandatory and balances judicial independence with public accountability, right? Then major things came into picture. Then yes, what is the constitutional legal bias basis? अगर मैं इन सारी चीजों की बात करूं तो what is the majorly the constitutional legal basis? Article 124 and Article 217B of the Constitution of India were really important. Deal with impeachment and removal of Supreme Court and High Court judges is a major important, articles that we look for. Okay, these are the articles that we look for under our Constitution of India, which actually deal with the impeachment and removal of Supreme Court and High Court judges. Then we can see the Prevention of Corruption Act, which can cover the public servants as well. That is what is covering under K. Veeraswamy case. And then we come with the power of what judiciary actually holds, that is doctrine of separation of powers, where judiciary is independent of from all the other bodies that we run, basically independent of executive as well, which is the body as well. Okay, so what major impact, if I really want to say, came with the picture of the Veeraswamy judgment was the reinforcement that judges are not above the law. They were treated above the law usually because of the position that they hold, but then there was positive impacts that came into picture because of Veeraswamy judgment. Then also there was certain a precedent was set already for the regulated and cautious prosecution of the judges as well. Yes, and they preserve the dignity and independence of judiciary while allowing the security about the same. There was certain criticism also made while we see the judgment. The criticism that we hold is it created a high threshold for initiating actions which could discharge accountability as well. Also, there was over dependence on CGI's discretion that could be misused or result in inaction. Also, there was a critical argument that leads to an internal closed door system lacking transparency. So yes, certainly we will always be aware that there is a little bit of transparency, not a lot of transparency with respect to the whatever the argument happens internally, right? So we needed certain developments while we saw all these things, and the current relevance. If I talk about what is the related developments and current relevance, are certainly the Judicial Standards and Accountability Bill that came into picture in 2010, and it aimed to establish a statutory mechanism for dealing with complaints against judges. Okay, and also it was proposed by a National Judicial Oversight Committee, but apparently that never had the approval of to be passed, so it never passed as a bill. Okay, then we saw in-house procedure also, so own in-house mechanism procedure that came into picture. It was non-statutory, it was very secretive, they didn't reveal a lot of things about the same. Then it also lacked enforceability for the same. So notable incidents also happened later point of time in the history of the judiciary system that we hold. Certainly the allegation against judges like Justice C.S. Karnan was also made, Justice P.D. Dinakaran was also made, Justice Sumitra Sen was also made. So all these dignitaries were also made liable against the same. Whereas when we talk about in 2019, there was this Supreme Court also dismissed a plea for the probe, which came for the sexual harassment allegations against CJI Ranjan Gogoi. So raising concerns over transparency. So there was a lot of, when we see a lot of history about judiciary, when we can come up with various things that came into picture. And that's why certainly these were the major highlights of the case. Then we came to the doctrine of presumption of constitutionality that came into picture. What is actually the doctrine? It was actually the ruling that came under the K. Veeraswamy case. It's not that important. It was under ruling, but yes, CGI, to have our CGI is really mandatory, and it should be there as a CGI. But the rulings that came later on, and have seen certain of the developments as well. So, when we talk about the doctrine of presumption of constitutionality is basically what any law enacted by the legislature is presumed to be constitutional. Okay, so any act that is coming out of the parliament is supposed to be a constitutional act, which is like, unless it is proven otherwise. So, if there is no challenges made on certainly on any act that has been passed as a that has been passed as an act, then we consider it to be a constitutional act only. Courts has been given the benefit of doubt to the legislature, assuming it will always act within the powers and is not actually violating the Constitution of India. So when we had the power as a parliament, we have lower house and upper house when they are making the bill, and when they are actually proposing it in the front of the speaker. And while we have such dignitaries sitting there, so that is what it is presumed by the court. It's a presumption that all the acts that are coming out are actually the constitutionally valid acts. Okay, so basically, this doctrine has certainly our origin of Anglo-American jurisprudence, and these are all very high-power words that you guys will not be able to understand as of now. Only the things that you need to understand is basically the concepts. What are these doctrine of presumption, and what is actually the judicial accountability of the judges? Why it's there? What is the relevance of that? So just to have the overview about the same, you just have to read and concise and have few pointers that should be there in your mind. So yes, what is actually the stand of Indian Constitution on the doctrine? The Indian Constitution does not explicitly mention this doctrine. So any of the doctrines that we are going to talk about, that you will be able to study, are not directly mentioned as such. But yes, their concepts have been adapted in Constitution, and we can see majorly the most of the concepts which had been adopted with respect to other acts as well. But it has been upheld and applied by the Supreme Court and High Courts through several landmark judgments. So yes, although these doctrines are not explicitly mentioned, but they have been kept using. As I already told, the Supreme Court and High Court are actually using it. The majorly, when we talk about certainly few major important pointers that you need to keep in picture are, that is, the burden of proof on it would always lie on the challenger. Constitutionality is to be preserved through these acts or the doctrines that we are going to consider, and there is a judicial restraint. So courts generally, when the courts are there, they defer to wisdom of the legislature, especially on the policy matters. The greater the presumption for economic social legislation, laws concerning economic for social policy are actually given the broader leeway. No presumption in case of fundamental rights violation. If a law clearly infringes on fundamental rights, the presumption is weaker or absent at all. Then we see certainly major, so these are certainly exception to the doctrine. It won't be applicable when fundamental rights are clearly violated. No reasonable classification would be given under Article 14, and the law is manifestly arbitrary. Right? So these are certainly the factors and exceptions to the doctrine that we have. And certainly, when I look back, there are certain landmark judgments that cater the doctrine. You might see it when you will be going to your law school. Certainly, few of the judgments that notably are Kedarnath versus State of Bihar versus Bihar Distillery. Navtej Singh Johar is a very famous case versus Union of India, where Section 377 was struck down, and it was made uh, basically it was made not according to the Constitution of India. So yes, we can see what all things that we can go ahead and have with this doctrine. Later on, when we talk about Supreme Court mandates 3 years legal practice for judicial service aspirant, this is a major topic. This was a highlight of the last week, I believe. And because of this, there were lot many of our aspirants, lot many of the aspirants have faced challenges while they were preparing for the judiciary examination, because they did not actually go ahead and had the practice done by them, and they just started, then they being the fresher just started for the started studying for the examination of judiciary. Judiciary is a very reputed examination that was conducted just after. So there are different states that they conduct examination, and each state has their own examination for judiciary, just like PSCs also have state related examination, but they also have a union examination like UPSC that we call, right? For judiciary, when students used to clear their 5 year law school, or they might be done with the 3 year LLB as well, they used to go and get the examination straight away. But now, court has mandated 3 years of practice, and it will be applicable to all the states as of now. So, when we look after all these things, certainly there are questions, because there are students who have not prepared, who just started preparing and didn't go for the practice for 3 years. Also, this was started with the MP as a state, and now it has been implemented in all other states. MP started with it with, there should be no backlogs, and there should be 3 years of practice. That is important. But then 3 years of practice was made important with respect to whenever a student is going for go and give the judicial examination, right? This was came into picture recently, and rationale behind the same was that judges must have a real courtroom experience. The freshers were lacking the experience that they had, and improves the quality of the judgment whenever they're going to come and give the judgment for the same. Because although they were going through this rigorous training, although they were going through this 1 year of 1.5 year of training, but then yes, this will make the judgments much more mature, and they lacked that maturity because they were just the freshers that were coming to the courts, and they were just pronouncing the judgments. Now, and that the major impact is on the judicial aspirants. जो बहुत सारे judicial aspirants थे, उनके ऊपर ये major impact गया है, क्योंकि now it would be really difficult for them actually to go ahead and start their practice. And now they, after, imagine the aspirants who were just preparing, and now after 3-4 years of preparation, they have to go for the litigation. There will be 3 years now, and after 5 years of law school, already they have, when they were might be 16, 17, 18, they might be there in the law school. 17, if they were the minimum age 17, that they were there in the law school. After 22, they might be preparing it for the judicial judicial thing, and then after 4 years of studying it, now they have to be doing 3 years of legal practice. Now they've wasted a lot of time into preparation and everything. It would have been better that they could have actually just started practicing as such. So it's a lot of time gap that is going waste, which is the biggest impact on the judicial aspirant as of now. And with this, all the three topics that we have done today are done. And I really want to know your opinion on how much impact it will create. There are major changes that are happening actually. Oh, when we talk about advisory jurisdiction, we have studied and covered this topic last time. So Supreme Court can give, Supreme Court is not bound to give the advices. So neither president is bound to accept the advices. President can ask, Supreme Court can answer, but even Supreme Court is not bound to answer. They can or they cannot. So there is no mandate that they have to follow, right? We have covered this topic last time, I believe. I really want to know your comments in the comment section. Why what are your thoughts, because there are major changes that are going to happen. Consortium is going to get dissolved. We will be coming up with 4 years of BLLB program, and then we have 3 years of mandatory practice, legal practice, to get into the judiciary system, and all these is happening in a span of just 1 or 2 months back. So yes, that is all that has been going on. And I really want to know your thoughts in the comment box down. And we'll be covering the AILET strategy session at 6 p.m. today. So do come and join the session. Okay, so bye bye. Take care, students.